Employers in Tennessee, Virginia, Maine, Utah, and Connecticut should be aware of several employment law reforms affecting non-compete agreements and pay transparency requirements, with key provisions taking effect this summer. First, Tennessee has enacted its first generally applicable non-compete statute effective July 1, 2026, prohibiting employers from requiring or enforcing non-competes against employees earning less than $70,000 annually. The law reflects a broader nationwide trend toward limiting post-termination non-competes for employees based on base wage amounts, while preserving employers' ability to use such agreements for higher earners. The statute does not apply to independent contractors and does not limit employers' use of other restrictive covenants such as non-solicitation or confidentiality agreements. The Tennessee law also introduces a presumption that non-competes of 2 years or less are reasonable, addressing prior inconsistency in Tennessee court rulings. Restrictions exceeding 2 years are presumed unreasonable but may be modified by courts. This framework effectively shifts the burden to employees to challenge the reasonableness of a 2-year restriction, providing employers with greater predictability in drafting and enforcing agreements. Second, 3 states, Virginia, Maine, and Utah, recently passed laws limiting non-compete agreements for healthcare workers. Virginia's law, effective for non-competes entered into on or after July 1, 2026, prohibits employers from making, enforcing, or threatening a non-compete against any licensed healthcare professional, with a $10,000 fine for each violation. Utah's law is similar, making non-competes with healthcare workers completely void as of May 2026. Maine's law, which took effect in April 2026, requires that any non-compete between an employer and a healthcare practitioner must recognize a patient's right to choose their own healthcare practitioner. Importantly, all 3 laws allow for non-competes in connection with the sale of a healthcare practice. In light of these new laws, employers should carefully review any restrictive covenant agreement before implementing to make sure it is compliant with applicable law.
Third, Virginia and Connecticut have recently enacted pay transparency laws. Virginia's law, effective July 1, 2026, will require employers to include a good faith salary range in every public and internal job, promotion, and transfer posting. The range must reflect a realistic minimum and maximum tied to the actual pay scale, comparable employees, or the budgeted amount. The law also bars employers from asking about or relying on an applicant's salary history. The Attorney General can seek penalties of up to $1,000 for a first violation and up to $5,000 for each subsequent violation. Aggrieved employees may also file a private right of action within 1 year of the violation. However, employers who receive notice of non-compliance have 15 business days to remedy the posting, which will bar any action for a violation. Connecticut's law, effective October 1, 2026, requires employers to provide a good faith wage range, plus a general description of benefits in job ads and to applicants and employees on request, upon hire, or upon a change in position. The law also prohibits employers from imposing restrictions on employees' ability to discuss their own wages or the wages of other employees. Workers can sue within 2 years for damages, attorney's fees, and costs. For more detailed discussions of related developments, please see our prior LaborSpeak post covering these topics, which we will link in this post. Please contact a member of Aiken's Labor and Employment team with any questions about these new laws or for any other labor and employment matters.